Deputy, I've prepared and made available to the House a paper on this, but I don't propose to go through the paper. I propose to very, in succinct fashion, very summary fashion, just highlight the points. And again, these arise from the reference on the last occasion, being well over a year ago, to an opinion of one Lord Belloff, essentially to say, and to attempt to rebut the statement which I had made on my contribution, that to insert the word sex into the Constitution without safeguards, without a proviso, will include sexual orientation, and therefore will open the door to same-sex marriages. I have made the point repeatedly that if that is what is intended to be put to the people, this is a democracy, and that ought to be put to the people in an open and honest fashion, and the will of the people would prevail on that. But to the extent that that was being introduced on the last occasion, I reserve my right to respond to it, and I do so in this fashion, Mr. Speaker. Again, in a very summarized fashion. To say that sex means male and female doesn't advance the question, Mr. Speaker. And I just refer, for those who are interested, to the decision in the Australia, re Kevin, Validity of Marriage of Transsexuals, 2001 Family CA 1074, in which the court held that those words male and female should be given their ordinary, everyday, contemporary meaning, but which the court nonetheless held included post-operative female to male transsexual persons. And so to say that something means something doesn't advance the issue when you don't define what that ultimate something means. To say that sex means male and female doesn't advance the issue if you don't define what male and female means, because you will just have a contest over what that means. That's summarizing quite a bit what is written, but I think that serves the purpose for now. Secondly, in that opinion of Lord Belloff, he referred to the judgment of Justice Omrod in Corbett and Corbett, which has been mentioned repeatedly throughout this country now. And essentially what Justice Omrod had said was that sex is determined at birth, and it's a test, an examination of one's chromosomes, gonads, and genitals. And my position has been, and the law is, that if that had remained the law, we would have no issue. But what has not been actually dealt with is that that is no longer the law. In fact, Mr. Speaker, if you look to the case of Bellinger and Bellinger, the House of Lords, in 2003, that House was called upon to consider whether that still remained the law. And insofar as the House determined that the biological sexual constitution of an individual remained the law, it seems to support the case of Corbett and Corbett. But it went further. It considered something which is very much akin to the Bahamas. It considered the United Kingdom's obligations under the European Convention of Human Rights, which does include the word sex. And to the extent that that European Convention of Human Rights contained the word sex without definition, what the UK House of Lords was called upon to consider was whether the UK was in contravention of its obligations under that European Convention of Human Rights. And it determined that it was. It gave what is called a declaration of incompatibility, that to maintain the position under Corbett and Corbett, where the word sex now applies in the UK through the European Convention of Human Rights, is incompatible. The UK doesn't have a written constitution, we do. But the reasoning applies that if you have a constitution with the word sex, and you then define sex as meaning biological features, that is inconsistent. In our language, that would be unconstitutional. So I just raise it for those who want to go and read that. And they really should read it. In fact, Lord Nichols of Birkenhead, at paragraph 18 of his judgment, said this: "At what point would it be consistent with public policy to recognize that the person should be treated for all purposes, including marriage, as a person of the opposite sex to that which he or she was correctly assigned at birth? This is a question for Parliament, not the courts." And so the House of Lords kicked the question down the road, but they made a determination, a declaration of incompatibility as to that law in England when interpreted through the prism of the European legislation. That's what we are now asking this Parliament to do. That's what we will be asking the people to do. And so very briefly, some other important cases on this. Just to remember that Bellinger and Bellinger, that declaration of incompatibility, was on the premise that sex was included in the word in the European Constitution. And although you couldn't declare in England that something was unconstitutional, because the European Convention is not really a constitution and because England has no written constitution, the highest declaration, negative declaration the House of Lords could have given was a declaration of incompatibility, which it did. There are other cases on it, Mr. Speaker, Mr. Deputy, which I will move through quickly because the paper will be made available, but I won't dwell on them. There are a couple more I want to dwell on, though. Mendoza. This is a Court of Appeal decision out of England itself. Gaydon and Mendoza, 2004, for All England Report 1162. In that case, the court found that the prohibition against discrimination on any basis such as sex included discrimination on the basis of sexual orientation, and this is what was said. The enjoyment, Article 14 had said that the enjoyment of the rights and freedoms set forth in this convention shall be secured without discrimination on any grounds such as sex. On the basis of that, Lord Buxton held this. Shockingly, in my opinion, but this is what he held. This court bears the burden of having to construe the convention as a living instrument. And I'll come back to this in a minute. What we perceive as the meaning of these words today do not necessarily remain the meaning of the words going forward. But this court bears the burden of having to construe the convention as a living instrument. It has to ask itself whether discrimination on the grounds of sexual orientation is excluded from the protection of Article 14, dealing with sex. Looking at that question in 2002, Lord Buxton says, it seems to me that there can only be one answer. Sexual orientation is now clearly recognized as an impermissible ground of discrimination based on the word sex. Further, those who want to have a forthright discussion should consider the House of Lords decision on appeal from Scotland and Shirley Pearson, governing body of Mayfield School, which was on sexual discrimination. And the House of Lords in that case based its decision that sex does not include sexual orientation on one section, Section 5.3 of the Sex Discrimination Act 1975, which we do not have in this country. And but for that section, would have, and indicated they would have upheld the decision of Baroness Hale in the Court of Appeal. But for that one section, which we do not have. And what Baroness Hale had said in the Court of Appeal is this: those who treat homosexuals of either sex less favorably than they treat heterosexuals do so because of their sex, not because they love man or woman, but because they are men who love men and women who love women. It is their own sex rather than the sex of their partners which is the problem. And on that basis, she equated sexual orientation with sex. That was overruled in the House of Lords on the basis, again, of Section 5.3 of the Sex Discrimination Act, which we do not have. Which, of course, leads lawyers and right-thinking people to realize that but for Section 5.3, which we don't have, sex would have included sexual discrimination in 2003 at the House of Lords level. Let's put it beyond discussion, though, Mr. Speaker. If you go to December of last year, December 2015, in Leanna White and Haley Vidikis versus Pepperdine University, the U.S. District Court Judge Dean Pregerson held expressly that sexual orientation discrimination is not a category distinct from sex or gender discrimination, simply on the basis of the word sex. This is what she said, to quote it: this court, in its prior order, stated that the line between discrimination based on gender stereotyping and discrimination based on sexual orientation is blurry at best. This is just December of last year. After further briefing and argument, the court concludes that the distinction is illusory and artificial, and that sexual orientation discrimination is not a category distinct from sex or gender discrimination. Thus, claims of discrimination based on sexual orientation are covered, not as a category of independent claims separate from sex and gender stereotypes. Rather, claims of sexual orientation discrimination are gender stereotypes or sex discrimination claims. She equated both. This is the District Court in the United States, Federal District Court, last year. Simply put, continuing her quote, the line between sex discrimination and sexual orientation discrimination is difficult to draw because the line does not exist, save as a lingering and faulty judicial construct. That is where the world is heading, Mr. Deputy. Similarly, the United States Equal Employment Opportunity Commission held in July of 2015 that discrimination against an individual because of that person's sexual orientation is discrimination because of sex, and therefore prohibited under Title VII of the Civil Rights Act. Just by including the word sex. In fact, on an international level, Mr. Deputy, and I'll come into the end of this, on an international level, that view goes back as far as 1992, when the United Nations Human Rights Committee held in a case called Tunen in Austria, that's communication number 88 of 1992, that, quote, sex includes sexual orientation. At paragraph 8.7 of its communication, the United Nations Human Rights Committee stated as follows: the committee confines itself to noting that in its view, the reference to sex in Article 2, paragraph 1 and 26 of the International Covenant on Civil and Political Rights is to be taken as including sexual orientation. All on the basis of just that word without a definition or without a proviso to that word. The Bahamas is not a signatory to that convention, but that is the road down which we're being asked to be taken. Speaker, the question then arises, if it is not the intention to open the door to same-sex marriages, why not insert a simple proviso? And a simple proviso is easy to draft. It will only be that provided that notwithstanding anything contained in this Constitution, any written law or the common law, no marriages shall be solemnized or recognized in the Bahamas except between a natural biological male and a natural biological female. If that is not the intention to open the door to judicial intervention, why not include the proviso? And the refusal to include the proviso does beg the conclusion that that is absolutely the intention. Mr. Speaker, let me just summarize it in this way. When we're talking about bills 1, 2, and 3, we're talking about citizenship. I've already explained my views on those bills, and that I will not support Bill 2 because it gives an entitlement to citizenship just by marrying Bahamians. But when we're talking about Bill 4, we're not talking about citizenship. We're talking about the clash between fundamental rights. We're not talking about even wanting to compel someone to hide themselves somewhere. We're talking about the religious fundamental right under our Constitution being on the same level as the fundamental right for freedom of expression and the fundamental right for freedom of speech. We're talking about them being at the same level, and we are acknowledging that there's a clash, and we're determining as a matter of public policy how to resolve that clash. And I'm making the point very openly and very, very strategically that throughout the world, putting that word sex includes the word sexual orientation and resolves that clash in favor of same-sex marriages. Thank you, Mr. Speaker.
Thank you, Honourable Member.